state will now give its closing argument.
I mean, not that it has anything to do with it, but my entire life until I was 18 and my grandfather passed away, I was going to be a police officer. And on May 7, 2019, she got her opportunity. And as a result, 62-year-old Kenneth Herring, who was unarmed and minding his own business, was chased down, detained, shot, and murdered by this defendant. And how do we know she shot him? Because we watched Officer Rich's body cam. And when he asked, who shot Mr. Herring? She said, I did. And you don't get the death penalty for committing a traffic infraction. And you know how much entitlement you have to chase somebody down, detain them, jump out your car, and run toward a stranger. He didn't know her. He didn't know why she was approaching his car, and demand that they do anything. He didn't have to listen to her. He didn't have to do anything she said. As he continued to ask her, who are you? And the audacity to come here and take that stand and blame everybody else. Now, before I jump into all the facts and all the evidence that you heard today, I want to talk a little bit about what your duties are. You're to be a fair and impartial juror, honestly seeking the truth. And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth. You have a duty to follow the law, and you are bound by the instructions and the law given to you by the judge. Now, you shouldn't consider anything that's outside this circle. Passion, public opinion, dislike of the police, any sentiment, sentencing, prejudice, penalty and punishment, conjecture, whether you disagree with the law or if you have any sympathy for the defendant. The only thing you should consider is the law, the elements of the crime that I'm going to discuss with you, any testimony that you heard during this trial, any expert testimony, and you will determine the credibility of the witnesses, any photos, any audio, any videos that you saw, the physical evidence, and your common sense. We don't ask that you leave your common sense at the door, and any corroboration. Now, you do have a duty to deliberate. And if a juror refuses to deliberate or discuss with the other jurors the evidence or the law, you may bring this to the attention of the judge. Now, let's talk about some legal principles. Now, you heard a lot about the presumption of innocence. Now, the presumption only exists until it is overcome by the evidence. So once you believe the defendant committed the offenses as alleged in the indictment beyond a reasonable doubt, the presumption is gone. Now, the state does have the burden to prove every material allegation in the indictment beyond a reasonable doubt. And we take that burden very seriously. Now, let's talk about reasonable doubt. Reasonable doubt is not proof to a mathematical certainty or proof beyond all doubt or absolute certainty. There's no number. It is beyond the doubt of a fair-minded, impartial juror honestly seeking the truth. And it is based on common sense and reason. Now, there are two types of evidence. You have direct evidence and circumstantial evidence. Direct evidence points immediately to the question at issue. So, for example, any witnesses that testified based on things they saw, things they heard, things they smelled, taste it, anything of that nature. That's direct evidence. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. For example, the DNA information that was presented to you when you learned that the major contributor on that firearm was a female and it was identified as the defendant. Now, the law does not favor one type of evidence over the other, so it is up to you how you weigh that evidence. Now, you may consider the personal credibility of any witness that took the stand. And it may have been shown in your presence, in their presence and by the evidence. So this applies to the defendant as well. What was their demeanor? Did they have any reason to lie? Did the facts they testified to match the evidence? Was there any corroboration? And is what they say believable? Now, we presented several eyewitnesses. That Attorney Tucker discussed. And you heard direct evidence based on things they saw and what they observed on May 7, 2019. Now, even though Attorney Tucker tried to twist their words, misquote their statements, they all stood firm in what they saw. And what was consistent between Ms. McCraney, Ms. Rosser, Ms. Jackson, and Mr. Williams was that there was only one aggressor on May 7, 2019. And that was the defendant. Now, you heard testimony from the defendant yesterday. And, she stated that she never heard 911 tell her to not chase. And then when I went through her testimony and the transcript of the 911 call, they told her 4 different times, either twice to go back to the incident location. And they told her not to follow him. But she said based on her perception and what she believed they meant was that she should follow him as long as she remained safe. Now, it is for you to decide whether there is a reasonable explanation for any inconsistency in the witness's pretrial statements and testimony when compared to the same witness's trial testimony. You are to consider all the facts and circumstances of any prior statements. You, the jury, must apply your common sense and your reason to decide what testimony you believe or do not believe. Now, it's not a memory contest. These events happened nearly 4 years ago. And the witnesses got on the stand and they testified to what they remembered that happened on May 7, 2019. And for the most part, they gave you everything. Now, you can imagine, if you went to a wedding and, you went to the wedding, you told your mother, the bride's dress was beautiful, the food was good, and you told your dad, they had a great open bar. The DJ was real nice. And you told your friend, the invitations that we received, they were just beautiful. Now, you may not have told each one of them all the details or specific details of what happened at the wedding, but what was consistent amongst the story is that I went to a wedding. And all of the witnesses were very consistent. That on May 7, 2019, Tiana McCraney advised you that she observed the defendant travel around Mr. Herring's vehicle and block him in. She stated that the traffic on that day was very congested on Riverdale Road. It wasn't moving. And when I asked her, was there any way after she blocked his vehicle in and detained him, could he get around her? Could he move in any way? And she said no. And what she also observed was the defendant jump out of her vehicle, irate and aggressive, and immediately run toward Mr. Herring's vehicle, screaming and yelling for him to get out of the car and cursing at him. Now, when you watch the defendant's interview, she never mentions to the detectives at any point in time that she yelled at him, that she screamed at him, and that she demanded that he get out of the vehicle. Her characterization was, I walked up to the car, I held the phone, and I said, I have 911 on the phone, and they want you to go back to the scene. And that all of a sudden, the victim just became very irate, grabbing her and pulling her into the car. And that's not what any of the witnesses saw. And you also heard from Ms. Rosser, who advised that she saw the defendant outside of Mr. Herring's vehicle punching him, being very aggressive, screaming and yelling. And you also heard from Ms. Jackson, who notified you that as she was leaving work and she made a left onto Forest Parkway, that she noticed the defendant's Jeep come flying down Forest Parkway, almost running her off the road, and other vehicles off the road, swerving in and out of traffic, which is ironic because she stated the only reason she was trying to get Mr. Herring pulled over because he was going to harm other drivers on the road. She wanted other people to be safe. And then when she caught up to Riverdale Road, Miss Jackson got up to Riverdale Road, she noticed that the defendant here, had caused an accident. She didn't know that she had cut Mr. Herring off and pulled in front of him. But what she did know was that she just observed her driving very irately. And so she pulled over because she was interested in seeing what happened. And what she saw was the defendant very aggressively banging on what she thought was Mr. Herring's window. But then what she realized was that she was actually punching him inside of the vehicle. And what Ms. Rosser and Ms. Jackson remember was her pulling that firearm. And when she pulled the firearm, she pointed the firearm in the vehicle. And what they recall is that she immediately shot. Now, the testimony of a single witness, if believed, is sufficient to establish a fact. So if you believe Tiana McCraney and you believe that she observed the defendant pull around Mr. Herring's vehicle and block him in, detaining him, then that's sufficient to establish that fact. Now, the law provides that criminal action shall be tried in the county where the crime was committed. And we did submit to you that this occurred on Riverdale Road and Forest Parkway, which is located in Clayton County, Georgia. Now let's talk about the charges. And this is where we will get into details about the facts and the evidence that was presented to you. The defendant is charged in count 1 with malice murder, count 2, felony murder, count 3, aggravated assault, count 4, felony murder, count 5, false imprisonment, and count 6 through 8, possession of a firearm during the commission of a felony. Now, I know there was only one death in this case, and we've charged 3 counts of murder. Now, the state of Georgia allows us to charge murder in various ways, and you don't have to pick one. If you believe that the state has presented sufficient evidence to prove that she committed counts 1, count 2, and count 4 beyond a reasonable doubt, you can enter a verdict on all of those counts. You don't have to choose one. Now let's talk about malice murder. Malice murder is when a person with malice aforethought unlawfully causes the death of another human being. Now, what is malice? Malice is the unlawful intention to kill without justification, excuse, or mitigation. its malicious intent can be formed in a moment. So it doesn't require premeditation. It can be formed in a moment. And it does not require ill will or hatred towards another. An intent may be shown in many ways. It can be inferred from the proven circumstances or by acts and conduct, or it may be inferred when it is the natural and necessary consequence of the act. So if you pull out a gun and point it at somebody, then you fire that firearm, then the natural and necessary consequence is that they may die. Now, we believe we submitted to you that the defendant acted with malice when she chased Mr. Herring's vehicle in her Jeep. She cut off Mr. Herring's vehicle with her Jeep on Riverdale Road, cornering him in, blocking his ability to move, detaining him. When she jumped out of her Jeep in an aggressive manner, immediately runs up to Mr. Herring's driver's side door screaming, cursing, and demanding him to get out the car, motherfucker. She tells Mr. Herring that she will shoot him. She draws her firearm from her waist. She racks the slide with 2 hands, and she shoots him. And you heard on the 911 call, you heard her say, "You hit my car." And she says that right before she shoots. Now, she's also charged with felony murder. Now, when a person, while committing a felony, causes the death of another human being, irrespective of malice, so aggravated assault, which is a felony, plus a death caused during the aggravated assault equals felony murder. So there's no intent to kill. Intent to kill for this count is irrelevant. It's not required. So a person commits an aggravated assault when she assaults another person with a deadly weapon. And no injury is required for you to find the defendant guilty on this count. And what is an assault? An assault is when a person attempts to cause a violent injury to the victim or intentionally commits an act that places the victim in reasonable fear of immediately receiving a violent injury. And a deadly weapon, a firearm, when used the way a firearm is ordinarily used, is a deadly weapon, and that's as a matter of law. Now, the evidence that we submitted to you for the felony murder charge for aggravated assault is the defendant pointing a firearm at Mr. Herring, placing him in reasonable fear of receiving a violent injury. And as a result, shooting Mr. Herring, causing a gunshot wound to his abdomen, which the medical examiner told you caused his death. So, in the commission of committing an aggravated assault, Mr. Herring died. Felony murder. Intent not required. And we know the defendant committed an aggravated assault because you watched the video. And you watched her in this video shoot Mr. Herring. Now, when the defendant pulls a firearm and she pointed it at Mr. Herring, then he reasonably believed in that moment that he would receive a serious injury. And therefore, the aggravated assault was complete. In count 4, she's charged with felony murder for the crime and felony of false imprisonment. Once again, intent to kill for this count is irrelevant. And a person commits false imprisonment when she, in violation of the personal liberty of another, unlawfully detains another without legal authority. And false imprisonment is a felony. Now, if you recall, when the defendant was on the stand yesterday, she did not want to state that she blocked Mr. Herring's vehicle in. But this is what you see in this photo. And that's what you heard on her interview when she said, I found an opportunity and I pulled in front of him and I stopped him. So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She's not post-certified. She's not a police officer. She has no arrest powers. Nobody legally told her to stop Mr. Herring's vehicle. And you heard a lot of talk from the defense attorney that he could have jumped up the curb and drove down the sidewalk. There was no duty for Mr. Herring to retreat. And as you heard Ms. Jackson say, who drives on sidewalks? So the felony murder in count 4 was complete when the defendant cornered him, restricted his movement, detained him without any legal authority. And during that false imprisonment, he was shot by the defendant, again causing a gunshot wound to his abdomen, which caused his death. False imprisonment was complete. Felony murder. Now, count 6 through 8, in possession of a firearm in the commission of a felony, is when a person unlawfully has on his person a firearm while committing a felony. And we submit to you that in the commission of the false imprisonment, in the commission of the aggravated assault, and in the commission of the malice murder, the defendant was in possession with the firearm. And you saw that in the photo. Murder is a felony, aggravated assault is a felony, and false imprisonment is a felony. Now, this is one of the most important parts to remember as you deliberate. A person is justified in using deadly force which is intended or likely to cause death or great bodily harm, only if she reasonably believes that such force is necessary to prevent death or great bodily injury to herself or a third person, or to prevent the commission of a forcible felony. Reasonable belief doesn't just mean whether the defendant believed it. The question is whether it was reasonable for her to believe it. Would a reasonable person believe it under the circumstances that you've heard in this case? Was it necessary? To be entitled to self-defense, the defendant must have needed to use this force to protect herself from an imminent threat of death or serious bodily injury or a forcible felony. The problem here is that a person is not justified in using force in self-defense if she is the initial aggressor. The defendant was the initial aggressor and therefore is not entitled to self-defense. So, whatever Mr. Herring did, once the defendant cornered him, aggressively approached his vehicle, and pulled out that firearm, doesn't matter. He was within every right he had to do whatever he did to defend himself. Because there was only one person on May 7, 2019 that was entitled to defend themselves, and it wasn't the defendant. Once again, the defendant is not justified in threatening or using force if she provokes the threat or use of force against him or herself, intending to use that threat or force as an excuse to harm the other person, is committing a felony. False imprisonment is a felony. So, once the false imprisonment was complete, when she blocked his vehicle and blocked his access, She was committing a felony. And if you are committing a felony, you are not entitled to self-defense. And once again, if you are the initial aggressor, unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. To allow an armed aggressor who confronts an unarmed, non-threatening victim to claim self-defense when the victim struggles to disarm the aggressor is contrary to common sense and contrary to law. On May 7, 2019, you heard testimony from Terry Robinson. There was an initial accident that occurred on Clark Howell. You heard testimony that accident did not involve this defendant. She had made no contact with the defendant. There was no argument with her and the defendant. Her vehicle was not struck. That accident had nothing to do with her. She didn't get close enough, she stated, to smell any alcohol or the odor of alcohol in his breath. She just interjected herself in a situation that had nothing to do with her. Now, what she wants you to believe is that when Terry Robinson was speaking in the background and he said, go, 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 that meant for her to jump in her car, chase down Mr. Herring, block his car off, apprehend him, and detain him. And we know that's simply not true. Because what you hear on the 911 call with Mr. Robinson, the only thing he says, and the only thing he said was, take a picture of the tag. Now, if we are to believe that take a picture of the tag means this, and you also heard from Terry Robinson that the defendant was already in her vehicle. She was already in motion. She was already prepared to do what she felt she was supposed to do in this situation. And then you hear the 911 call. And you hear the 911 operator tell her, once they realize she's chasing Mr. Herring, ma'am, we advise that you do not chase or follow. And she said she understood 100%. But yet she still continued. And you heard testimony from Ashley Jackson that she was speeding down Forest Parkway so fast, weaving in and out of traffic. I mean, she is chasing Mr. Herring, almost causing accidents, almost running other people off the road. And you heard the defendant say, and when I finally caught up to him, I had an opportunity. Because in her mind, she was going to stop that vehicle by any means necessary. And she did. And it's unfortunate for Mr. Herring. And you also heard testimony of the rage she had, how angry she was, how aggressive she was. But when she stood on the stand, when she got on the stand yesterday, everything was so calm. And when her attorney is asking her questions, she has every answer detailed, laid out, how she was just a people person. She was just trying to do things to help. She wanted to help all the other drivers on the road. And when I was asking her questions, she became very combative and aggressive. And it was always my perspective, what I thought. No, the 911 officer, our dispatcher did not tell me to not follow, not chase. Because she knows best. And at the end of that 911 call, after she shot Mr. Herring, her whole attitude, I'm safe, but he ain't. But she wants you to believe that she was concerned and she wanted an ambulance, and she wanted to assist, and she wanted to help and make sure he was okay. She didn't care about Mr. Herring. The defendant had multiple opportunities to do something else. To go back to the incident location. To go back home. Not pursue. This had nothing to do with her. And the idea that she could command somebody to do anything. The only person that introduced a deadly weapon in this situation was the defendant. And but for her introducing that firearm, Mr. Herring would still be here today. You can't poke a bear and then when the bear turns around and attack you, want to claim self-defense. It doesn't work that way. She should have minded her own business. Now, this is the real reason we're here today. Now, the law doesn't allow us to talk about Mr. Herring's background and history and go into details about that. But there is no reason, absolutely no reason Mr. Herring shouldn't still be alive today. Preparing to spend the holidays with his family and friends. There's absolutely no reason. And but for the defendant's actions on May 7, 2019, he would be. You saw and heard the evidence. And all of the evidence points to one conclusion, that the defendant is guilty. Now, you won't be able to take back the videos and the audios of the 911 calls as you deliberate, but if you want to be able to listen to those again, to see them, just let the bailiff know and we'll let you do that. But this isn't a complex case. The defendant had no right to do what she did. None. And so I'm going to ask that as you deliberate, that you find her guilty on each and every count in the indictment.